Hi, I'm Greg Dell here with Alex Palamara, and we want to talk about a case that Alex recently handled against the Standard Insurance Company. Alex, give us some background on this case and what was the importance that somebody watching this video could learn from your experience in helping this disabled client.
Well, my client worked for the Metropolitan Police Department, which is Washington, D.C.'s police department. Unfortunately for him, off duty, he got into a car accident. His car accident led to obviously back injuries, shoulder injuries, neck injury, and it led him to be unable to perform the duties of his occupation. Luckily for him, his employment provides this long-term disability insurance policy with the Standard should he become disabled from performing the duties of his occupation. He filed a claim with the Standard. The Standard took a look at the claim. They requested some documentation from his doctor, some forms for the doctor to fill out, and the doctor was not cooperative or did not fill out the forms in a timely manner. So the Standard went ahead and denied the claim, essentially stating, we're denying your claim because we couldn't do a pre-existing condition evaluation or examination to find out whether your conditions were pre-existing or not.
All right, let's talk about that, the pre-existing condition limitation, because that's probably one of the single most consistent reasons for denying a claim that we see when someone initially files. What is that?
So most policies have what's known as a pre-existing condition limitation. They will not pay benefits if your condition that you're claiming disability on, if you had it before your coverage under the policy. Now, in most policies state if you're covered under the policy for longer than a year, then the pre-existing condition limitation goes out the window. It does not apply anymore. So if you've been covered under the policy for a year and 1 day, and for that time period you suffered from multiple sclerosis prior to you being covered under this policy, a year, 1 day later you make a claim, they can't say anything. It's too bad, so sad for the insurance company, but it's in their policy. So if you're covered under the policy for less than a year, they have the right to review your claim to see if it's pre-existing condition, and they have the right to deny your claim if it in fact is pre-existing.
So if somebody starts with a new employer and they have an accident, if this particular police officer had his accident, let's say 11 months and 29 days in, and he had prior back treatment, within that past 12 months before he became employed, then that would be a basis to deny his claim.
It could be bad because they can make the argument that your condition was pre-existing and the car accident just kind of, it's the straw that broke the camel's back, you know? And that could be a good grounds for them to deny the claim.
Okay. So you have the pre-existing condition issue, which we look at in every claim that we file and discuss that with claims, because sometimes people call us 10, 11 months into employment or having the coverage, and we say you got to do whatever you can to stay employed there to get past this day. And I've had many cases, as have you, where it's like 1 or 2 days before the cutoff, and then that person doesn't get benefits.
Correct. I've seen it many times, so you have to stay at work as long as you possibly can.
Okay, so you mentioned here the basis for denial was like a lack of cooperation from the treating physician. So what were you able to do to help this claimant?
Well, clearly my client was not suffering from a pre-existing condition. He was a police officer. He was working the job. He was on the beat, as some people call it. So clearly he didn't have back, neck, shoulder issues that prevented him from doing his own occupation prior to this automobile accident. But unfortunately, it was denied for pre-existing condition reasons because his doctor was not cooperative in giving out these, filling out forms and giving him medical records. And one thing that you need on any claim is doctor cooperation. So when I got this case and started doing work on the administrative appeal, the one thing I was able to do, the first thing I did was contact the doctor's office. It seems like the most simplest thing. Sometimes doctor's offices, they're obviously busy. They're there to treat patients. They're not there to fill out disability forms. But sometimes with a little help from the attorney, we can get these forms completed, get the work done. And we got the forms completed. We got the medical records together. I filed an appeal to the insurance company, letting them know that their denial is wrong. Here's the requested information, and I gave them arguments of why my client satisfies the definition of disability, and we got our client on claim pretty darn quickly.
That's great. And then you continue to help the claimant on a monthly basis to make sure that his benefits are going to continue?
Of course. I mean, they could ask for more forms to be filled out by the doctor, and if you don't turn them in, it's a reason for them to deny the claim. You have to do whatever you can to prevent the denial until you're able to go back to work, until you're able and ready to go back to work, or until the policy ends at age 65 or 67.
All right, so if you have a claim with the Standard Insurance Company or any other long-term disability insurance company, feel free to give any of our lawyers a phone call. We always provide a free consultation, and we look forward to the opportunity to speak with you.